Hey everyone, welcome back to the Irretrievable Breakdown podcast where we talk about all things divorce. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and I'm joined by my co-host Nicole Bikakis, who is also the managing partner of our firm. And today we are going to talk about what the best interest of the child actually means. So that is the standard that the judges use when they're determining legal and physical custody. And there are a number of factors that they consider when they determine what is actually in the best interest of the child. But before we get into that, Nicole, I had a new baby this past Tuesday, but in talking to you before this podcast, sounds like you're the one who's pretty stressed out here today. So why don't you tell me, how's your day going so far?
It's been a little stressful. We've had kids are out of school. So we're dealing with that. But most importantly, I have someone coming to repair our garage, and that's not going very smoothly. So
Gotcha.
I don't know.
So we're getting started a little bit late here, and that's okay.
Yeah, sorry for the delay.
Yes, that's
You
all
have
right.
the new baby, but I'm the one running late.
Yes,
So
yes.
not a good look.
I had a new baby. My baby was supposed to come this coming Thursday, but she decided to show up, 10, 11 days early, something like that.
She wanted to take advantage of summer.
Yeah.
More
It's going well.
summer.
It's going well so far. She's pretty easy, doesn't make a peep. It's my second child, which makes it first child was like a little easier and all they do is sleep all day. But now I'm also managing a 2-year-old, which makes it somewhat more of a challenge. But yeah, it's going pretty well so far.
I don't know how long she's going to be staying quiet for, but enjoy it while it lasts.
Yeah, that's true. So anyways, best interest of the child and what the judges consider. Why don't we get into it? So when judges are either making initial custody orders or they are modifying existing custody orders, they are supposed to make the determination of what happens with regard to custody based on what is in the best interest of the child. And that has to do with both legal and physical custody. So legal custody is which parent or both parents make decisions about where your child's going to go to the doctor, where they're going to go to school, what religion they're going to follow, things like that. That is legal custody. And physical custody is the actual schedule of where the child lives, what days he or she spends with mom or dad, and what the schedule looks like. So when determining both of those, the judges are considering what is in the best interest of the child. And orders can either be initially made or orders can be modified whenever the court finds that there has been a substantial change in circumstance, which warrants a modification of the either legal custody or the physical custody schedule. So let's get right into it. So there's a Connecticut statute that lays out the factors that the court is supposed to consider when they are determining custody. It's 46B-56, and then it's subsection C within that statute. And what it says is that when making or modifying orders, the court shall consider the best interest of the child. And in doing so, the court may consider, but shall not be limited to, one or more of the following factors. So that language is pretty loosey-goosey, where it says the court may consider these factors, and they're also not limited to these factors. So basically, judges can sort of do whatever they want. They can make up their own definition of what is in the best interest of the child because they don't actually have to follow any of these factors, and they are not limited to these factors. But generally speaking, judges, there is this framework within the statute that will give a list of things that a judge will look at when determining custody. So we'll go through, I'm not going to go through every single one of the factors. You can look those up. There are, I think, 14 of them. No, there's 17 of them. But we're going to go through a number of them to kind of go over what judges are looking at. But so, Nicole, anything to add based on what I said before I get into the factors?
Just that I think this is one area that people who are in a divorce or in a custody proceeding find extremely frustrating because the subjective nature of this analysis means that you have no idea what a judge really is going to do if you can't come to some kind of agreement with your co-parent and resolve this without the need for a hearing or a trial. And it also is a scenario where even when you have lawyers, each of you respectively have your own lawyer, lawyers can't do a lot to predict necessarily what a judge is going to do. It's extremely subjective, and it's going to depend on what day you catch the particular judge that gets assigned to your hearing or trial. So in that regard, it can be a very sort of daunting piece of a divorce or the custody process, which is entirely about custody and legal physical custody, is that you don't really know what's going to happen or what a judge would do, and sometimes that can make it hard to come to an agreement with your co-parent.
Right. And at the end of the day, judges are human beings. They're all different. They all come into it with their own biases, their own way of viewing the world. So knowing that, I feel like we say this in every one of our podcasts, it's always best to try to resolve your case by agreement whenever you can. First off, it's just going to cause a lot less stress, emotional stress, financial stress on your family, but it will give you some degree of control where at least you can control the outcome of your case. Maybe you don't love the result. You probably don't. Generally speaking, a good agreement is when neither party loves the result, but you at least have some degree of control where you're not going to be totally surprised by the outcome. Now, with that in mind, sometimes the other side is just going to be so unreasonable that you can't reach an agreement and just, it's impossible and you have to have a trial. And in that scenario, these are the things that the judge is likely to consider.
I mean, if you're in a divorce or custody proceeding, you're obviously having certain difficulties with coming to agreements or seeing eye to eye with your co-parent. Now, that being said, though, what is in your child's best interest, more often than not, like you and the person you had that child with may have more common ground than you think, and you guys might be more aligned than what a judge who has no connection to you guys might think is in the best interest of your child. So consider that as well when you're in this process and you are coming up against disagreements with your co-parent, and understand that trying to figure out between both of you, coming up with compromises as to what is in the best interest of your child still may be better than what a judge is going to decide is in their best interest. And the reality is judges don't do a lot of unique details in their decisions regarding custody. When you're coming up with an agreement with your co-parent, you guys can be detailed about specific things concerning your kid and come up with a very specific to you agreement, whereas a judge is going to come up with a much more general agreement that they likely put in place for many different cases that come across their desk. So
I've heard
just
the
really
analogy
keeping that in mind.
I've heard the analogy that in trying to reach an agreement, you and your lawyer, if you have one, you can be like a surgeon where you can be very specific on where you make your cuts. But if you have a trial, judges are butchers, and they're just going to look at your case and they're going to chop things down the middle, whether that's custody or your assets, et cetera. And they're churning out tons and tons of cases. They're not going to take the time that you are able to take in trying to reach an agreement with your spouse. So
right. And then at the end of the day, most importantly, you have to carry out this agreement with your ex-spouse, your co-parent. And that means that if you can find a way to work together to come to an agreement, it's always going to be better for trying to have it enforced after the fact than if you're forced into a specific order because a judge ordered it. So another very important thing to consider.
Right. So the first factor, and a lot of these I'm going to breeze through, they're sort of self-explanatory. First is the physical and emotional safety of the child. When a judge is making a determination as to custody, they're of course going to consider the physical and emotional safety of the child involved. Also, the temperament and developmental needs of the child. So when they're thinking about which parent is going to have the child, they're looking at the child and what sort of child it is. Is it a very sensitive child who's going to, would maybe not do as well with, a number of transfers from one parent to the other during the week? Or is it a more resilient child who's going to be less bothered by that? So they're really likely to look at what your child is like when making a determination. So if you think that's relevant, your child's temperament and what the schedule is, make sure you make that clear to a judge during your trial. You want to present that evidence of what your child is like if you think it's relevant. Nicole, do you have anything to add to that?
Well, I do think part of the difficulty with even presenting evidence to the judge on these standards is that it is tricky to get certain information about your child before the judge sometimes, because there are all these hearsay rules that we have to consider about when you're actually at a point of presenting evidence to a judge. And typically a judge is appointing either a guardian ad litem or a family relations officer to conduct an evaluation. And that GAL or that family relations officer is the one that's sort of gathering this information and speaking to the child. And then they just bring back a recommendation a lot of times. So again, it's getting the evidence for these factors before a judge. It's not always straightforward. And so that complicates your ability to argue certain things to the judge.
Right. And you need to be thinking about these factors before you're having a trial, because if you're having a custody trial, chances are you have a guardian ad litem or family relations who has done an evaluation. So you really want to make it clear kind of the temperamental needs of your child before you're getting to a trial, because you want that third party to consider your child's needs when they're making their recommendation.
And that really means cooperating with the guardian ad litem and the family relations officer. They are the ones that are conducting these evaluations and making recommendations, and that the court is really going to heavily weigh in their decision. So you want to make sure that you are not just cooperating, but taking it really seriously and being very forthcoming with information and thinking about all these factors as part of the interview process that goes into these evaluations.
Right. Yeah. Being respectful and responsive to those evaluators, tremendously important. Because if you act poorly, it's going to reflect poorly on you to that person, and they're going to question your ability to parent your child. So your communications with that third party is very important. The third factor in the statute is the capacity and the disposition of the parents to understand and meet the needs of the child. So that kind of goes hand in hand with the last one about the needs of the child. It's whether each parent is able to fulfill the needs of the child in making them feel sort of safe and secure in the household. Fourth factor is any relevant and material information obtained from the child, including the informed preferences of the child. So a lot of people often ask, my child said they want to live with me, can't my child just live with me? No, I mean, it's a factor. So your child does not get to decide, but it is a factor. So that informed preference of the child, it becomes more relevant as your child gets older and more mature. So if you have a 15, 16-year-old child, and they express a preference to live in one place, that's going to carry a lot of weight. Judges sort of, I don't want to say defer to the wishes of older children, but they take them seriously. So keep that in mind. And, but it becomes less relevant as your child is younger. If you have an 8 or a 9-year-old, it becomes more of a gray area in how much the court is going to consider it. People often ask me, I've heard my child, once my child turns 14 or something, they can decide. That's not true. There's no bright line rule of when a child can make a decision. It's just, every situation is different as far as the age, and not just the age, but also the maturity of the child. And again, it's going to be that third party person, whether it's family relations or a guardian ad litem, who's really hearing from the child and assessing their maturity and credibility in determining whether, how much weight that child's preferences should carry.
And they're also going to weigh it against, is that their preference because of certain behaviors by one of the parents, in whether it's coaching the child to say those things or actively disparaging the other parent and trying their best to keep the other parent out of their lives. If there's evidence to show that the parent with, whether it's primary custody right now or the parent that the child ultimately wants to stay with, if that parent has been engaging in really counterproductive conversations to alienate, and that's not a legal term, but in essence, to alienate that child from the other parent, that's also going to be considered. And it's going to count against that child's preference.
Right. So that's one of the later factors. The eighth factor is any manipulation by or coercive behavior of the parents in an effort to involve the child in the parent's dispute. So again, that's going to reflect very poorly on the parent if the court or the guardian ad litem, that neutral party, determines that the child is being coached by the parent or being disparaged, disparaging the other parent to the child. So make sure you are not involving yourself in that behavior with your child. You want to keep them out of the process as much as possible. The sixth factor is the past and current interaction and relationship of the child with each parent, the child's siblings, and any other person who may significantly affect the best interest of the child. So the court's going to want to consider sort of what the relationship is like with each parent when they're determining what custody should be, and whether that child is very comfortable. Maybe there's a parent who isn't home all that much during your marriage or hasn't spent a ton of time with the child, and they don't have as close a bond as the other parent. The court's going to consider that. Or, relationships with other parties. So if somebody, if one of the parent is moving into a new household with a new significant other, and, that person has a strained relationship with the child, or a healthy, a strong relationship with the child, or maybe that person has children from their relationship who the child is going to be living with. Basically, the court is just considering all of the relationships that a child would be exposed to under a kind of the proposed parenting plan of each parent. They're going to factor that in determining what schedule makes sense. So, Nicole, do you have anything to add to that, or not really?
Yeah, I think maintaining sibling relationships is a very important factor that judges will consider. I mean, a very obvious point too is that if one person hasn't really had much contact with the child for years, and then they come back into the picture and want to have some custody and have a kid live with them, like that's not going to really happen right away. So the status quo of this child's life and where this child has lived and what this child is used to and the environment and relationships they've grown accustomed to is going to weigh heavily when a judge is considering all the factors, and whether a parent who hasn't really been involved should get custody or visitation, or what that should look like.
Right. And then another one of the factors is the ability of each parent to be actively involved in the life of the child. So, if it's a parent who travels a ton for work and then they want primary physical custody, well, that's not really going to work. If you are not able to be around, you can't ask for a schedule that would require you to be around all the time.
However, though, on the flip side, again, there are some parents that have these very challenging work schedules that make it requirement or need that they have, whether it's extended family or childcare, step in to kind of assist while they are at work. And courts will enable parents. Parents have to work, and a court's not going to necessarily penalize a parent who has to work. And if they do have the ability, whether that's extended family like grandparents, or it's a live-in nanny or something of that effect, they'll enable them and say, yeah, they get the right to use the other childcare options to enable them to have custody of the kid. Assuming again that it's not that they're completely absent and they're traveling for days and the child has no contact with this parent during that time. But I think it is false to assume, and people think this quite a bit, that, well, they work and therefore they shouldn't have a shared physical custody schedule because they're not around. No, a judge is going to let them use childcare or use their extended family to step in and assist them with their parenting responsibilities, again, to a certain degree.
Right, exactly. Like, I'm not talking about somebody who like goes on the occasional work trip and is gone, for a Thursday and Friday or something. I'm more talking about the person who's gone all the time and really can't even, you don't want to have a nanny just doing the parenting instead of you on a consistent basis. It's more childcare is there to kind of fill in the gaps. If you get out of work at 5 o'clock and daycare or school end at 3 o'clock, it's getting that hour of coverage. I mean, judges are going to be very receptive to childcare in that scenario. So it's sort of, there's no bright line rule on that one. So another factor, which is somewhat similar to what we've already touched on, is the willingness and ability of each parent to facilitate and encourage such continuing parent-child relationship between the child and the other parent as is appropriate, including compliance with any court orders. So again, it's similar to not disparaging the child or coaching them, things like that. If the parent is incapable of sort of complying with court orders or encouraging a strong relationship with the other parent, the judge is going to consider that in making its orders. If a parent has a track record of not following court orders, then that is likely to just limit their parenting time, whether it's their parenting schedule or it may result in the other parent who's not behaving poorly getting sole legal custody or joint legal custody with final decision making to the parent who is not behaving poorly. So again, sort of how you interact with the other parent and having a good record of being respectful to the court and following court orders is tremendously important when you're kind of fighting for custody of your children.
Although, I would say in practice, this is a very frustrating thing for parents, where you have custody orders in place and one person is just like not following them or making it very difficult, or constantly being late. And on the one hand, while a judge could in essence take away time from them or give the other parent more legal custody, broad decision making authority, and all of that, the reality is the court's not really well positioned to referee these disputes, and so it's oftentimes they want the parent who's enduring this behavior from the other parent wants to come to court because they want the judge to hear the bad behavior and what they've been doing. But at the end of the day, the court can't do all that much about it. And it's not a very satisfying result because sometimes you can't really change the orders in a way to stop that behavior from happening. And it can just continue to happen. And so this is one of those things where the practical consequences of not being a parent that's facilitating and encouraging the continuing parent-child relationship with the other parent is that you're really just hurting your kid in the end. I mean, that's really the practical consequence. But the judge isn't, or the court isn't really well positioned to again do anything to truly punish the other parent for that
Right.
type of behavior.
Yeah, generally speaking, it has to be like pretty egregious behavior for the court to actually do anything. And what you often see is somebody filing a motion for contempt because the other side violated the court order, and they spend a ton of money or a ton of time or both by going to court, and they have their hearing, and the judge finds the other party in contempt, and the punishment is basically don't do it again. Nothing happens, and
Exactly.
it's tremendously frustrating. So yeah,
And you've gone through the whole process where you've put yourself in this like really unpleasant process of having to file a post-judgment motion and deal with it. Likely, you may also be dragging your kids into it a bit because whether you have to get a guardian and ad litem or a family relations officer involved, now your child has to speak with someone. It's just such an unpleasant experience all around that sometimes you do have to weigh what is going to be the likely end result here? Like, what's the best thing I could hope to happen if I win on this contempt? And, that's where hopefully your lawyer is counseling you really honestly about how, the likelihood of getting an order that's going to satisfy you or really change the other person's behavior. Sometimes, depending on, again, what the violation of the parenting plan is, it's sometimes really not worth the whole
right.
process of going
Like
through the
somebody
post
being late
judgment.
to drop off, sort of consistently like 5 to 10 minutes late. Yeah, really annoying, but probably not worth pursuing, a contempt. Now, if somebody's just not showing up at all and essentially completely canceling visit, I mean, that's different. And that probably does warrant filing a motion for contempt. And the judge is likely to take action, whether putting financial penalties in place or changing the custody schedule because one parent just is refusing to follow it. So again, depending on your situation, talk to a lawyer and determine whether it makes sense to pursue a contempt.
I think one thing that people, again, find very frustrating is a lot of times people are filing motions to force the other person to hold up their end of the parenting plan, and especially where they have shared physical custody, or if it's just like, specified parenting time, that they show up and take advantage of that time. And if they're not doing that, but you as the parent who is following the orders want them to do that because enables you to work. It enables you to do other things, expecting that the other parent's gonna be watching the kid on their time, and they don't. That's one of the most frustrating situations because there's not much they can do about that. They can't force a co-parent to actually parent and exercise their parenting time if they're just not doing it. And it sounds like a situation where if they just take the parenting time away from that parent, I don't know that that's really a punishment if you're coming from a position where the parent's not taking advantage of that parenting time. So that's not really a punishment to them. And so that could be a very frustrating situation.
Right. So, all right. And then a couple more factors. I'm going to go through three of them that are somewhat related. The 10th factor is the child's adjustment to his or her home, school, and community environments. The 11th is the length of time that the child has lived in a stable and satisfactory environment and the desirability of maintaining continuity in such environment, provided the court may consider favorably a parent who voluntarily leaves the child's family home pendente lite. So while the divorce or custody process is ongoing, that's what pendente lite means. So if they leave pendente lite in order to alleviate stress in the household, the court's going to consider that. And 12, the stability of the child's existing or proposed residences or both. So basically, the court sort of wants to maintain the status quo as much as possible. They're not going to want to pull a child, out of a school district, for example, or even out of their residence. Of course, it becomes a necessity in a divorce for the parents to part ways with one another and live in separate residences, but they're going to consider, kind of the benefit to the child of staying within their home that they have lived in and spending a considerable amount of time in that home. So it really comes down to consistency. Obviously, children, they're going to be going through a lot of change with parents divorcing or separating, and going from living both of them in one household to two households and the parents sort of moving from one to the other. So the judges are going to be thinking a lot about continuity and stability for children when they're determining kind of custody. This is more about physical custody and less about legal custody. So,
but then again, we also have to consider the fact that the courts are now starting from a presumption that shared physical custody and joint legal custody are typically what's in the child's best interest. And, maintaining contact with both parents is presumably in the child's best interest. And so when reviewing all these factors, you're starting from that presumption. And so the burden of proof kind of shifts where if you're going to go against that presumption, you really have to provide evidence to show why a shared physical custody schedule or more contact with the other parent is not in your child's best interest.
All right. So those are sort of the basics on what the judges in Connecticut are considering when they are determining what is in the best interest of the child. Again, they don't have to follow any of these rules, or they may sort of make up their own factors that they want to consider. The statute does not require them to follow these factors, but generally speaking, they are. And this is a good framework to look at when you're trying to make your argument for why you want your preferred custody schedule to be in place. So, Nicole, before we part ways, do you have any last wise words for our listeners?
I would say just that, the relationship between a parent and their child is a very fundamental right that people have. And a court's not going to punish a parent by stripping them of access to their child unless there's really strong evidence that it is against their best interest. So this isn't just slight personality differences or preferences over, I like to have my kid eat only organic and they feed them whatever. Like at the end of the day, it has to really be something where the child's well-being is obviously going to be, is not going to be served by having the other parent have custody as well. And because again, a judge is not going to get in between a parent and their child without, strong evidence to show that, stripping that parent of certain custody rights or access really is in the best interest of the child. And you really have to be prepared to show, again, you might not like something the other parent is doing, but that does not rise to the level of a concern or risk that the court might step in and take away custody from that parent.
So that's going to do it for us today on the Irretrievable Breakdown podcast, where we discuss all things divorce. As usual, if you have any additional questions, you can contact our office. And if you're looking for representation in a divorce or family law case here in Connecticut, you can contact our office, Dolan Divorce Lawyers. Thanks for listening, and we will see you all next week.